So that is my.
But look, ultimately, as a bank, it is regulated by the state authorities, since it's a state bank, as well as to a certain extent by the Reserve Bank of India. Why should we presume that they will not look into the any regulatory failures in the bank?
Any fraud above 3 crores is directed to be investigated by CBI. But here the quantum is not above.
Lordships, there is a delay 48 days in depositing a cost fees, which has been deposited last year instead of 30.
You have deposited, the amount has been deposited.
It has been transferred to.
The delay in deposit of costs, Mr. Surat Singh states that the cost of rupees 5 lakhs has been deposited.
Last year, Lordship.
Go with a delay of 48 days. The delay is condoned. Yes.
Grateful, Lordship.
25. Hello, I may request a password. Allowed in item 25, if I may request a password. I'm being led by Mr. Akhil Sibbal.
Okay. We'll keep it some other time because we have some other matters. We'll keep it on Monday.
Very well.
26.
Please, clear abuse of process of law matters.
Fine. The washing application has been dismissed on the ground that you are running an unregistered finance.
General allegations, that is not the case. That is not the case at all. Now 4 lines for the impugned order, which is only general allegations against me. What was argued? It is not a charge sheet form, part of the charge sheet. Charge sheet, you not kindly consider. But power of attorney was executed in favor of my father, not in my favor. That was in 17/8/1998. My father sold the property on 12/7/2001. The purchasers are in possession of the property from 2001 onwards. In 2017 and 18, 3 civil suits were filed, one by his daughter, one by his sister and other. Questioning the very same sale made by the first accused. Those suits are pending, in which he remained ex parte in 2017 and 18. Then in 2019, he makes a complaint.
Stage please, yes, he considered that said.
Clear abuse. After.
Washing, but you can seek discharge or whatever other.
So far he is concerned, I understand that. My humble submission would be, Murad, the entire transaction involves only my father, 1998, then 2001. At that time, I was hardly 18.5 years old. I got nothing to do with that transaction. I did nothing.
Whether you have subsequently had a role or not really where we can consider the stage of washing. Discharge, yes, at that stage a little bit more
this will give room for another round of litigation. We'll file my when you have to appreciate, but it is so clear that it is when it is.
Mr. Nagamurthy, no, there are limitations on 482 quashing petition, and there's not a case for quashing.
May I take 1 more minute's time, subject to my not permitting me?
Sorry?
1 more minute's time, minutes?
Yes.
Murad, you not kindly see after how many years Murad, your affair has been registered. 1998, Murad, power of attorney in favor of my father, not in my favor. My father sold it in 2001, Murad, to third parties. Third parties have been in possession of Murad all these years. In 2019, Murad, a complaint is made. Murad, at the time of transaction, 1998, I was hardly 18.5 years old. There is no allegation against me. Now, Murad, after 18 years of the original transaction, Murad, when the purchasers have been all along in possession, for the first time, Murad, is made. Civil suit, 3 civil suits are pending. 18 years. Kindly make one observation that observation made by the High Court will not stand in my way, my lords, when I move for discharge.
That we can say. There's no error in the order of the High Court declining to quash the criminal proceedings exercise of its jurisdiction under Section 482 of the Code of Criminal Procedure 1973. However, the observations in the impugned order of the High Court will not prejudice the petitioner in either seeking in applying for discharge or at any latest of the proceedings, as the case may be.
Liberty to file the discharge petition.
We have said that. Not liberty, but we said it will not come in the way of these observations will not prejudice you in your application for discharge. Yes.
Great.
Now you are expanding it not just to Delhi, but to the rest of the country.
My reason, my lord, I have my own reasons, my lord.
Who's appearing for the Union of India here? Notice was issued by Justice Arun Mishra and Justice M.R. Shah in 2019.
And
Can you file a proper affidavit explaining, he's dealt with issues of suicide by children? It's basically more of
already filed an affidavit. We'll file a detailed affidavit also with respect.
may I?
Learned Counsel appearing on behalf of the Union of India states that response to the petition, a comprehensive affidavit of these steps which are being taken to allay the grievance in the petition shall be filed. The affidavit be filed within 4 weeks, list thereafter.
May I, my lord, may I have only 2 minutes, my lord, my lord, permit, my lord.
No, we'll just allow them to file an affidavit and then
My
it can
lord,
come.
they have filed, my lord, the latest affidavit they have filed, my lord.
When have they filed it?
My lord, it's my lord on the last date, my lord, which is my lord on 19th of my lord, May 2023, my lord, they filed.
So let him, he wants to, it's a social issue, so let him file an affidavit, yes.
Grateful.
A specific date may be given, my lord.
Yes, yes. Yes.
I beg to appear, my lords. We have compiled a chart of 28 states and UTs who have filed an affidavit here. It doesn't have 8 states and UTs, actually 3 states and 5 UTs, my lords. May I hand over?
On the implementation of the Nalsa judgment.
Yes, so we've culled out from their affidavits, my lords.
Some of the states have not filed affidavit, your lordship. Till the
28 states and
3
UTs.
states and 5 UTs have not filed an affidavit.
8 have not filed, my lords.
8 total.
States and
3, 5 UTs. Which are the states which have not filed? That's all right. You can ask one of your juniors.
Write down and give it, my lords.
We give them a little time to
State of
give them a
HP
little
has
time to file and direct the chief secretaries to ensure that affidavits are filed by them.
That's so that the chart can be then completed, my
You
lords.
can update the chart. Ms. Aishwarya Bhati has placed a tabulated statement indicating state-wise compliance with regard to the direction with regard to Direction 3 contained in the judgment in Nalsa versus Union of India 2014 5 SEC 438. Full stop. 3 states and 5 union territories are yet to file their responses, namely.
I'll give the.
Just ask your junior to put it down. We direct that the above states and UT shall file their responses no later than within a period of no later than by 31 August 2024. Full stop. A copy of this order shall be served on the Standing Council for the above states stroke UTs with copies to the chief secretaries. List on.
Your lordship, may I pray one thing, your lordship? There's another writ petition, your lordship. Your lordship, there is one more writ petition where your lordship has issued notice, your lordship. Writ petition of 535 of 2023. That is covering the broader issues of including this filter. That may be tagged on this matter, your lordship.
I am not aware, my lords. I'll take details from.
535. Writ petition number 535 of 2023.
Just ask one of your juniors to
Yes, my
examine
lord.
535 of 2023 and let the court master know by the evening.
Please, my lord.
I have brought the copy of it. Let's see.
Malas, I will see.
All right, just see that. Yes.
I'm waiting.
535 of 2020.
29.
Yeah, please, Lordship. This is for appointment.
You're appearing to be appointed an arbitrator.
Not two requests, Madam. Let it be the Bangalore Center, Bangalore, Madam.
Bangalore Arbitration Center, under the auspices of the Bangalore Arbitration. How much is the claim?
Well, there is some joint development agreement. Because the petitioners are in America, they have to come here, Madam. I'm happy to concede that. Let it go to the Arbitration Center, Bangalore. Let them appoint an arbitrator and
With an arbitrator from Bangalore here, you tell us whom we can appoint.
But we have suggested, my lord, sir.
Why don't you both give us a name? It's just 1.38 crores. No point in appointing a retired.
the Arbitration Center has a set up, my lord, where they by claims they
All right, we'll do it.
resolve.
In view of the arbitration agreement between the parties, we refer we direct that the arbitration shall take place. There's an arbitration agreement. The arbitration agreement between the parties is not in dispute. But stop disputes having arisen. The composition of the arbitral tribunal would have to be the arbitral tribunal would have to be constituted. Full stop. The parties are referred to the Bangalore International the Bangalore Arbitration Center, so that necessary directions in that regard can be issued.
Request, my lord. Respondent's name has undergone a change. It has become an LLP. Maybe report. My friend wouldn't know, but
All right. The name of the respondent having undergone a change.
I'll write it to him.
Then council liberty to amend the petition. Amendment be carried out during the course of the week. Just give it to him so that he can, and then the order and petition disposed of.
We'll do it, my lord. Grateful.
This matter with only the
Appoint an arbitrator, Lord.
How much is the claim in Indian rupees?
It's around 2.27 crores, my lord.
2.3 crores. We are appointing you as an arbitrator in one matter. Yeah, please look at it.
My lord, one more request. my lord.
Lordship, the place is
The place of arbit is Indore. my lord.
Indore in Madhya Pradesh.
That's all right. You can do it online now. All arbitrators do their arbitrations online.
If your lordship permits, we have suggestion for few name. If your lordship permits.
Yeah, we are appoint now. Yes. Admittedly, there's an arbitration agreement between the parties. But stop. We appoint Ms. Mayuri Raghuvanshi, counsel, as sole arbitrator under the Arbitration and Conciliation Act 1996. But stop. The sole arbitrator shall be at liberty to fix her fees in consultation with the parties. But stop. Parties have agreed that to the extent feasible, the arbitration proceedings would be conducted online,
Grateful, my lord.
subject to the directions of the arbitrator.
Item 31.
अच्छा है ना छोटे छोटे claims हैं these people.
Lords, I beg to appear for the respondent. This doesn't lie, my lords, because clause 16.5 is a jurisdictional clause for courts, and clause 18 is actually a clause which says it's governed under Colombian law for a Colombian authority to appoint an arbitrator, and it's a very interesting clause. It's actually a med-arb clause.
Let's see. I've got it here. Let's see.
If your lordships will come to clause 16.5 first, which is at page 41, which falls under the head sorry, page 42. In fact, it falls under the head miscellaneous. Miscellaneous is at clause 16, which is at 41, and 16.5 is at 42. It says the agreement shall be governed by and construed in accordance with the laws of India, and all matters pertaining to this agreement or the matters arising as a consequence of this agreement will be subject to the jurisdiction of courts in Gujarat, India. That's one clause. Now, please have a look, Manoj.
It says arbitration will take place in Bogota.
Correct. Now, this is very interesting. It's actually a very interesting clause. If your lordship sees the first paragraph of clause 18, it talks about a conciliation. So it's a non-mandatory provision, says parties are, if they want to go for conciliation, they can go for conciliation in accordance with the rules of the arbitration and conciliation of the chambers of
If
commerce.
conciliation is not successful, it will be committed to arbitration by either party for final settlement in accordance with the Arbitration and Conciliation Center of the Chamber of Bogota.
I'm deeply grateful, and if your lordship was to please see with the wordings, it's very interesting. It is what is unresolved in the conciliation that goes for arbitration. Now, they haven't even gone for conciliation. So if you haven't even gone for conciliation, and it's a matter of, in fact, in my respectful submission, your lordships has some judgments under Indian law on this issue. One is Jagdish Chandra and one is your lordship, my lord's own judgment, which I would say your lordship should not even apply here because this is a Colombian law governed clause. Please see the bottom of it, because it's very clear that it says it's Colombian law. So I would not, in fact, hesitate in even interpreting this clause under Indian law. It's not for us to interpret. So my respectful submission should be that this section 11 should be dismissed.
They seem to have lost interest. Will you dismiss it in default?
I'm deeply grateful.
Yes, ma'am. Because after your counter, nobody is appearing. If they come, we'll see. We'll restore it and hear you then.
I'm deeply.
Yes.
32. Obliged. Please.
Two arises out of two connected agreements where I'm seeking the appointment of a tribunal. So they have filed their counters on the day before, respondent 3, because also, my lord, I'm asserting some parties were not signatories to the arbitration agreement, but, my lord, are connected and part of the group company's doctrine of lordship's judgment. But with regard to their...
That can move the arbitrator.
Yes, then...
Tell your lordship there's a problem. There are two, sorry.
What about those arbitrational parties who are signatories to the arbitration agreement?
Well, there are two cases which are there before your lordship. In first case, which is a joint venture agreement, your lordships will kindly give me a minute and note down these dates. They are important. The first joint venture agreement is 2nd of June 2016. This is in arbitration petition number 47, which is item 32.1. Now, please note in this, there are two parties, Zonta Holdings and Bauer. Bauer is the name of my client, the company.
They are Zonta.
They are Zonta. Zonta Holding and then Zonta Infra is their subsidiary. So the first agreement is a joint venture agreement, which is 2016, Zonta Holdings and Bauer. There is an arbitration clause here, which is clause number 14 at page 77.
Yes.
In this, my only defense is that there is a pre-reference mechanism which they have not followed. That's clause number 14.1. But we had to try to settle it amicably. They've done nothing.
So here, really speaking, one can appoint an arbitrator. Subject
I am leaving it at that. I am not taking your lordships to anything else. Now, please mark one thing, and that's my defense in the other case.
So 32.1, we can appoint an arbitrator.
32.1, I leave it to you.
What's the claim there? What's the claim there?
There is a monetary claim of about 180 crores. But I'll just say one thing, my friend can continue, Milord. The first agreement that my friend is referring to contemplates an arbitral tribunal of 3 members. The second agreement, Milord, which is interconnected, contemplates a sole arbitrator. We were requesting, Milord, if it can be the same tribunal, a consolidated hearing or even separate hearing.
Now, what about the first matter that is...
Yes, now let me come and
then we can ask them to respond.
Yes, absolutely. So grateful. Now, the second matter, which is actually the lead matter, is arbitration petition number 49, item 32, 49 of 2023.
Yes.
In this, the basis of section 11 is an ESDF agreement, which is Equity Subscription and Debt Financing Agreement, the date of which is 21st February 17.
Yes.
I'm sorry, I'll just repeat. ESDF, 21st February 17.
Yes.
Now, this ESDF agreement is entered into between 3 parties. That's my other client named Mr. Patrick in his individual capacity. Please note that. His clients are Zonta Infra and Zonta Holding. Now, as the names of the contract suggest, the first contract is whereby both of us agreed that we'll have a joint venture company and we will engage into XYZ. There is no liability. In fact, I have a pleaded case before your lordships that he's trying to mislead this court when he says both the contracts are connected. They are not connected. First is a joint venture agreement. The second agreement is where my director in his individual capacity has purchased from him and has financed debt, which is what the agreement also says. Now, there is an arbitration clause there. I agree to that. No problem. That is clause number 15.6 at page 123 in case number 47 itself. I'm taking page numbers of only the first case.
Yes.
Now,
in 47,
yes,
the arbitration agreement you said is clause 14.
Yes. In, however, ESDF, the arbitration clause is 15.6
Right.
at page 123 of petition number 47.
Okay.
Right? Because I'm giving page numbers of only one. I don't want to confuse you. Now, there is a parallel third agreement, which is an SBLC, sort of a line of credit that I give to him. Again, my company gives, in which there is no arbitration clause. He's not even invoked that, so I'm not going to. Post the second agreement disputes, ESDF, there was a settlement agreement which is entered into. Now, that is very important. The date of that is 6th October 22. That your lordships will find at page number 132 of petition number 47. What he does in the, what he does in the settlement agreement is he says that, yes, I will pay you this money in XYZ period. There is no arbitration clause there. He wants to go back to the parent agreement, whereas my settlement agreement says that the previous contract is over. Please have a look at that. Now, that specific clause.
Settlement agreement says that which contract is over? The
ESDF.
The ESDF.
Yes, clause number 13, page 135. Please have a look at that. That's the most important clause of petition number 47. Clause 13, page 135.
Now, his grievance is that you have not implemented the settlement agreement.
And that the settlement agreement is entered into because of coercion on him. He has to get it declared. How can he invoke section 11 for that? Your lordship's judgments from way back.
Except for the fact that the settlement agreement was entered into in lieu of his claim, in satisfaction of his claims under the ESDF.
Yes.
If he says that the settlement agreement has not been implemented, right? Or that the whatever defense, can he not then fall back on the ESDF agreement to get that issue adjudicated?
In fact, the point of law that arises in this case. Now, let me show to your lordship's GIMPEX.
Because but for the ESDF, there would be no settlement.
Yes.
Right? And we must construe this in a broader sense to facilitate arbitration. Now, but for ESDF, there would be no settlement. It's a settlement of disputes within the ESDF agreement. If that settlement has not, according to them, come through, surely they can invoke arbitration.
Let me only show law on this specific point because I've done some work. There is a judgment by your lordship.
Unless the settlement agreement says that his claims are extinguished. His claims are not extinguished.
Well, in fact, the settlement agreement recital says what? It says parties have agreed to rearrange and revise the inter se relationship, which means that this is what survives now. It is not the parent agreement which survives. The SPLC as well as the SPLC.
It's an ovation service.
Yes. So once novation occurs,
I'm challenging.
That's again for the arbitrator. And they're challenging it on the ground that I'm really never a party to that. So whether it was by coercion, not by coercion, it's for the arbitrator.
My submission.
So what we'll do with this? We'll appoint an arbitrator now. Now tell us what is the claim in both the matter.
Their claim is some 200 odd crores. I am the one who's pocketed out of money. They've not paid me back. There are allegations of siphoning against the Indian party. And now they say that they have a 200 crore claim. I'm not getting into the merits, Manoj. I don't want to.
So whom should we appoint?
I apologize.
Yes.
Number 3 is the ESDF, or to the JV agreement, or to the BLC. A party in the settlement. My role in the entire.
All right, 1 second. Now, who are in the second matter, namely 49, ESDF agreement is between, you said it is between the petitioners Zonta Infra and Zonta Holding.
Yes,
Then you
and
said,
Patrick.
and Patrick in his individual capacity.
Patrick in his individual capacity.
That's all.
That's all.
No, my lord.
Nobody else.
These are the three
In
parties
the-
to the ESDF, what your lordship just narrated.
Right.
The two petitioners and Patrick.
Right.
Patrick, my lord, is a shareholder of a family company called Bauer, which is the respondent in the other petition, which is the joint venture partner. This joint venture, my lord, was formed only to make supplies to Zonta Infratech, to the petitioner.
And Bauer is the company of which Patrick is a shareholder in his
Yes,
individual.
and director.
So
And-
in so far as what the way we understand it is, in the first case,
Yes,
which is actually the second case, 32.1,
yes.
there's an arbitration agreement between Zonta Holdings and Bauer, the German company.
Please.
We'll appoint an arbitrator there.
Please, my
In
lord.
the second case, we'll appoint an arbitrator as between Zonta Infra, Zonta Holdings, and Patrick.
Yes,
We will appoint the same arbitrator in both cases.
I'm grateful.
You can apply it before the arbitrator for impleading Bauer.
Yes.
Because look, Bauer it's a family company. You can move that because that's consistent with our judgment in the group of companies
Very well.
doctrine.
But I must just clarify when you're
Us now, sort of going behind the veil and,
But anyway, the tribunal has to decide it.
Tribunal
Whether
has-
I have to implead them or they stand impleaded and get. But may I just make one clarification so I'm not.
protect your client. We'll protect your client. Right now, in the second matter, or really the first matter, we'll appoint an arbitrator in the dispute between Zonta and Patrick. And the issue as to whether any other party should be implemented, we'll leave open for the to be urged before the arbitrator. So that will protect your client today, because otherwise we'll have to decide the issue. We'll have to decide your defense, which will take us at least another hour, because we'll have to look at facts. We'll have to see what was the conduct of the parties, whether there was a representation that you would be buying, that you were the person standing behind.
Let the arbitrator decide that.
Yeah, that's better.
Yes.
So now tell
Let me make
us,
just one
to the
clarification,
appoint, as so many of these cases, we have been appointing, young junior counsel in our court as arbitrators because, they're commercially wise and, we can, but tell us now, you want because of this, he says his claim is 180 crores. Should we appoint a former judge? Do you want a counsel?
Would your lordship consider, I know the seat is Bangalore. I think most of the parties are Bangalore. So when your lordships are considering.
I am in Germany. Whether it's Bangalore or anywhere else.
Yeah.
So then should we refer it to the Bangalore Arbitration Center?
Let them appoint.
There's a Bangalore Arbitration Center.
Let them appoint.
Of the money which was lent to them.
Nothing on that.
Please clarify that.
Yes.
Please clarify.
We'll say.
Proceeding. Find a court petition. This thing.
What we'll do is that having due regard to the nature of the claim, and instead of now just saying Bangalore to expedite, we'll appoint Justice Bopanna as the arbitrator.
Very well.
Yes.
Nothing else.
Your lordship may even do that perhaps with the consent of the parties, because that second matter, just to clarify, my lord,
Should we appoint
the
Justice Bopanna
arbitral clause requires
by
three.
consent, subject to reserving your rights.
My right that there is no arbitration clause, I want to argue that.
Right.
If not here under 11, at least before the arbitrator.
Right.
And the rights
And
of
that
my learned
respondent
friend's
one
client to say that he should not be implemented. That your lordships are not doing today.
This is on the-
Arbitration petition 47 of 2000 that's a little order. Two arbitration petitions have been instituted under Section 11 of the Arbitration and Conciliation Act 1996. Arbitration petition 47 of 2023, correct me if I'm wrong in any information. Arbitration petition number 47 of 2023 it pertains to a joint venture, arises from a joint venture agreement dated 2 June 2016 between Zonta Holdings and Bauer. All right?
It's now called Zion Holdings. Zonta Holdings changed its name.
Zonta
ZI?
Holdings, is it Zonta Holdings Limited or Zonta Holdings?
Private Limited, now called Zine,
Zonta Holdings Private Limited, into brackets, now called.
Zine Holdings Private.
Can you just give that?
ZI.
I'll do that.
Just ask the juniors to, so that.
And it's also Bauer GmbH, so I'll write all those names.
And Bauer GmbH. But stop, the arbitration agreement is contained in clause 14 of the JVA. But stop. Arbitration petition, the arbitration agreement is not in dispute. Arbitration petition 49 of 2000 the arbitration petition 49 of 2023 relates to an equity subscription and debt financing agreement into brackets ESDF agreement dated 21 February 2017. Full stop. The arbitration agreement, the ESDF agreement is between Zonta Infra and Zonta Holdings.
Yes. We'll give your lordship the full name. Yes. We'll give your lordship the full name.
I'll do that.
But it's Zonta Infratech and Zonta Holdings.
It's Zonta Infratech and Zonta Holdings Private Limited.
Private Limited.
And Mr. Patrick Bauer, on the other hand. Full stop. The arbitration agreement is contained in clause 15.6 of the ESDF. Full stop. The respondents have adverted to a settlement, an alleged settlement dated 6 October 2022, which according to the petitioners was obtained, which according to the petitioners is vitiated by coercion. Full stop. In both the cases, the existence of the arbitration agreement is not in dispute. Full stop. However, in arbitration petition 49 of 2023, apart from Mr. Patrick Bauer, there are how many other parties? Two other parties who contest, who dispute the maintainability of an arbitration against them on the ground that they are not parties to the contract. Full stop. With this backdrop of the dispute, we are of the considered view that the arbitration petitions under Section 11 of the Arbitration and Conciliation Act 1996 can be dealt with by constituting an arbitral tribunal comprising of a sole arbitrator. It has been agreed that instead, in place of a three-member arbitral tribunal, the appointment of a sole arbitrator would subserve the ends of justice. Full stop. In that view of the matter, we appoint Mr. Justice A.S. Bopanna, former judge of the Supreme Court, as sole arbitrator. Full stop. The arbitrator shall fix his fees in consultation with the parties. Full stop. However, it needs to be clarified that the reference to arbitration in arbitration petition 49 of 2023 shall be as between the petitioner and the first respondent.
Second respondent.
You are the second respondent or the
First and second.
But Patrick Bauer is the respondent too.
You are the second respondent between the petitioners and the second respondent into brackets, Patrick Bauer. The issue as to whether any other parties are liable to be impleaded as parties to the arbitration agreement is left open to be determined by the arbitral tribunal.
Your lordship may clarify, your lordships have expressed no opinion.
The standard is, this is a private tribunal, that's a criminal proceeding, the standard of proof is different, the nature of the investigation is different. We don't have to
Just
make-
one request, and that is important.
Yes.
The disputes are only arising out of these two agreements, because what they've tried to do is they are trying to cloud the second petition, which is 49, to also include SBLC, where there is no arbitration clause.
What
So
we
please specify that it's only with respect to these two, because my case in SBLC is that they've siphoned off funds.
The dispute, the disputes which have been referred to arbitration in the above terms pertain to the JVA dated 2 June 2016 and the ESDF agreement dated 21 February 2007. The petition.
So great.
Obliged.
Item 33.
Your Lordship, may I beg to appear for the respondent in this matter? There are efforts of settlement being made with the petitioner, Your Lordship, and we have agreed that the matter may be referred to mediation.
Mediation or?
Very well, Lordship. Nothing has happened for years, but we can try mediation.
Right. Parties have agreed at this stage to a mediation under the auspices of the Mediation Center of the Supreme Court.
Yes, Lordship.
Yes, Your Lordship.
They shall appear before the Mediation Center at 2 p.m. on next
Any day, Lordship.
week.
All parties are here, so foreign parties are there, so we are representing them.
All right. Next week.
Next week.
Yes.
What we can do is we can appoint an arbitrator. We can say party shall first go to mediation. If mediation doesn't succeed by 31st of August, then the arbitrator may enter upon
Yes,
references. All right, that's what we'll do.
Deeply obliged.
The arbitration agreement between how much is the claim?
This is a claim of possession first. This is a commercial property to be delivered. There are mean profits as well. So that is to be determined.
So whom should we appoint?
May I suggest Justice Bhatt in this case, Lordship?
All right, we'll appoint Justice Ravindra Bhatt. In view of the arbitration agreement between the parties, it has been agreed that a sole arbitrator may be appointed under the Arbitration and Conciliation Act 1996. Full stop. Shri Justice Ravindra Bhatt, former judge of the Supreme Court, shall accordingly stand appointed as sole arbitrator. Full stop. Since parties have expressed a desire to explore the possibility of a mediated settlement, they shall appear before the Mediation Center of the Supreme Court at 2 p.m. on Tuesday.
Tuesday, Lordship.
Take a date, Daldo. If the mediation proceedings, if no settlement is arrived at in mediation by 31 August 2024, the arbitrator shall be at liberty to enter upon the reference and proceed thereafter. Stop the arbitration petitions accordingly disposed of. The arbitrator would be at liberty to fix his fees in consultation with the parties. Then 34.
Obliged.
Deeply obliged.
Please, my lord, I'm appearing for the respondent. My lord, the advocate on record, Mr. Das, has taken ill. We have informed the other side also. We only seek 2 weeks to file our reply.
Then file the reply.
The next Monday is
2 weeks. Keep it on a particular day.
Please.
$35.
My lord, I appear for the petitioner in item 35, my lord. This is a matter, my lord, where I have invoked the company doctrine, my lord. But I have been served with the reply of the respondent number 1 only day before yesterday. I am seeking to file a rejoinder, my lord, to bring on record documents showing conduct and commonality.
Are you a party to the arbitration agreement?
I am, my lord. I am respondent number. My friend is for respondent number 2.
Who is not a party?
Not a party.
So what we can do is, subject to your agreeing, we can appoint an arbitrator.
But I have some other objection, subject of course to
any serious objection. Or?
Because the issue here is not they were to obtain these subscriptions. We subsequently found, as we tightened our procedures, 17,000 milords fake IDs. So there are criminal complaints also filed. My concern is there is criminality. Now the purpose of this arbitration is perhaps not his 5.5 crores or whatever he wants. Because now he will say that the matter has been referred to arbitration. Disputes are purely civil in nature. You don't examine whether there is cyber fraud or impersonation, etc.
But that's a matter for the arbitrator because you are Maxter, right?
Yes, no.
And you appoint the petitioner as a distribution partner.
Correct, no.
So according to you, there were certain fake IDs.
Yes, no.
Right, which he generated.
Yes.
But that's a matter of also.
No, that could be I understand, that could be whether some money is owed or not owed. But my concern is this: if there's criminal, in Vijay Drolia, Lord, in one paragraph, your Lordship said, if there's criminality, my Lord, at least there may be a case not to refer.
But that's all right.
Then Lordship will only protect me to the extent, my Lord, that my concern is this, that they will say now the court has referred the matter to arbitration. This is a case for quashing. I have the civil disputes and not any number of judgments. Your Lordships have said, but on civil nature, there will not be a prosecution.
You filed an FIR.
We have filed complaints, my Lord. They're still under investigation.
My lord, may I respond to that? Firstly, my lord, my arbitration petition is prior in time. two, my lord. They have filed a criminal complaint before Gurgaon court, my lord, where there is a closure. So therefore, I don't know what is the
complaint in Chennai also that is pending.
But once there's a closure in Gurgaon, my lord, they run
Go on uninfluenced.
We say that R2, he may move an application before the arbitrator, which will keep open for the arbitrator to decide in view of our judgment.
Which feels not only para 169 of Cox and Kings.
Of Cox and Kings judgment, yeah.
That your lordships have to make a prima facie opinion about not whether to even.
We are not referring you to arbitration at all.
Lordships are right. Lordships.
That's why we are doing that. So how much is the claim?
They have claimed in their notice 5.5 crores, my lord.
But the total claim and counterclaim is about 18 crores plus damages, my lord.
So should we appoint a counsel as an arbitrator?
Some named up, of course, we had suggested some retired judges. I can find over the list, but I leave it to your lordship, my lord.
Like give it for whom?
May I suggest Justice Sen or Justice Bhatt, my lord? Or Justice Bhanumati.
The claim is not very large.
It's a small claim, it's just 5 crores.
I mean, it's not in any particular order of preference, my lord. It's just.
My lord, or perhaps a judge from the High Court of Delhi, my lord.
That's what we have suggested.
There is an arbitration agreement between the parties. Full stop. There's an arbitration agreement between the petitioner and the first
Number 1.
Full stop. Hence, the disputes and differences between the petitioner and the first respondent are referred to the. It has been agreed that that a reference to a sole arbitrator may be made. Full stop. The disputes and differences between the petitioner and the first respondent are referred to the sole are referred to Dr. S. Muralidhar, former Chief Justice of the High Court of Orissa, as senior counsel, and formerly Chief Justice of the High Court of Orissa as sole arbitrator under the Arbitration and Conciliation Act 1996. Full stop. As regards the second respondent, it would be open to the petitioner to move an appropriate application before the sole arbitrator for impleadment, which may be decided in terms of the governing provisions of law. Full stop. The arbitrator may fix his fees in consultation with the parties. The arbitration petition.
My request on that it should not be construed as any opinion as far as the any criminal proceedings that I have initiated.
Reference to arbitration, the reference to arbitration of the disputes under the contract will not be construed as any expression by this court on issues which may arise in the criminal proceedings.
I'm very good.
And on the merits of the impleadment also. I'm sorry to point this out.
No, absolutely not. We have not. Otherwise, we would have impleaded you. The very fact that we have not impleaded you means we have not expressed any opinion.
Yeah?
I'm very grateful.
Now, Parmeshwar, which are the states which have not implemented our judgment?
I just circulated a note here. The state sharing. I have a note, minutes. I have a very detailed note in this.
You have the note here?
Yes. What is this kind of take to know?
Mr. Solicitor, that is the updated position you have now of who has.
I have the updated position till yesterday night. Till yesterday night, we were served affidavits and compliance. Because I just wanted to bring your lordship notice. This is the 6th or 7th time the lordships are asking them to pay up allowances and pay allowances. Your lordships kindly see the major defaulters. Let me just point out from page 6 onwards. Well, that's a number of high court on allowances, my lord. So that issue I'll come to. But your lordships,
because allowances you can't deduct TDS.
It is at all protected under section 192 and section 1014 of the Income Tax Act completely, because it is for money spent that allowances are paid. So there's no question of TDS, but I'll come to that a little later. If your lordships kindly see from page 6, Allahabad. Take 6 minutes. The Lordship sees, so far as Yellowbad is concerned, my lords, there is more or less compliance. I shouldn't take. I think there are minor difficulties which will get ironed out, my lords. So far as Andhra Pradesh is concerned, there is substantial non-compliance. I have marked
Substantial?
non-compliance. Your Lordship sees the last two columns. So far as payment of revised allowances are concerned and payment of arrears of allowances, my lords, most judicial officers have not received it. Most judicial officers haven't received it.
Fixed, my laws may just for payment of arrears.
Must be. I just wanted to bring to your lordship's attention. The 7th time your lordships are extending time. Repeatedly, your lordship, I've recounted all those orders in the first 3 parts of my notice. At best, my lords, August 15. There are states which have moved IAS asking for 6 months, 2 years. Orissa on its own.
15th August.
15th August. All states, my lords,
A note has been submitted by Mr. K. Parmeshwar, then the Amicus Curiae, indicating the status of compliance with the orders passed by this court on.
Well, that's 3 orders. Well, that's 27/7/2022.
27 July 2022 to 30 July 2023.
19th May 23 and 4th January 24.
19 May 2023
and 4th January 24.
Then there's 23rd November also, no?
That is only for extension, my lords. Your lordships again. For the substantial order, your lordships.
And 4th January 2024. Full stop. Those seven opportunities, 7, right, have been granted by this court to the states to comply. It appears that full compliance has not been effected and several states are in default. Full stop. The note highlights the states in default. And we will deal with them. Full stop. They are dealt with CRETIM, Andhra Pradesh, the Learned Standing Council, Learned Standing Council, Standing Council. Ms. Prerna Singh, appearing for the state of Andhra Pradesh, states that she has instructions to the effect that the payments which were to be made to the judicial officers have been made.
Whatever could be uploaded has been made.
Whatever could be uploaded.
Portal. There is a portal for the uploading of bills of arrears, which is the main. If my lords will see the last column, that is the main non-compliance that has been attributed to us.
Ms. Prerna Singh, Learned Standing Council for the state of Andhra Pradesh, Learned Council for the state of Andhra Pradesh states that the portal through which bills were to be uploaded that payments have been made to the extent to which bills were uploaded on the portal, on the web portal, which was opened for that purpose. We'll stop. Should we say, Mr. Parmeshwar, that this may be verified?
There's clearly non-compliance because judicial officers spoke to me yesterday night. Number of the All India Judges Association is also here, my lords. There is no doubt, my lords, most states have been lackadaisical.
All right. We will say that, on the other hand, both the Amicus Curiae and the All India Judges Association, which is represented in these proceedings, have categorically stated that that full compliance has not been effected. Full stop. We direct that a meeting be held by Monday between the Registrar General of the High Court of Andhra Pradesh, the Chief Secretary.
Would your lordship then direct that committee to meet? Your lordship said institutionalized it, and that committee, all the relevant people are part of that committee.
Be convened by the committee appointed by this court in its order dated
4th January
2024.
SCDJ.
What do we call it?
CSCDJ.
The CSCDJ. Preferably on Tuesday, we say, preferably on Tuesday next, so that in case compliance is still to be effected, it is completed no later than by 15 August 2015. Full stop. A compliance affidavit shall be first shared with the CSCDJ and thereafter filed before this court, indicating compliance, failing which this court will be constrained to adopt contempt proceeding against the officers of the state if full compliance has not been effected. Then
Bombay, Millards. If your lordship sees Bombay at page 8, Millards, most of it is in substantial compliance except for the part so far as TDS is concerned. On TDS, your lordships will pass an omnibus orders on all high courts. Would your lordships only see, this is unfortunately, your lordships will see, if your lordships, the second last column, what they've been doing is many state governments have again tinkered with your lordship's order on allowances. After your lordship's order, there's no question of the state governments now saying that this is not permissible under our rules. We will not allow it. Mobile handsets can't be. Your lordships, remember during the hearing also this question on mobile handsets, ACs,
that we'll deal with separately.
Furniture, ACs. So an omnibus order on the count that there's no question of now deviation from your lordships.
That we'll deal with.
So far as Bombay is concerned, only this, because they have now said we'll take a call on mobile handsets and AC and furniture.
That we will.
Otherwise, there has been substantial compliance so far as Bombay is concerned. They have taken effective steps.
Which are the states which are not compliant?
Calcutta. West Bengal has moved an IAF for extension of time with us.
We'll give you a time till 15th of August to comply by 15th of August.
I don't want to come back, seek further time.
It has to be, because 7 opportunities have been granted to us. All states have paid. I mean, how can West Bengal say we will not? Then you say that, look, then you can sit at home, will not take any work from judicial officers. They're all working there.
May I say this? May I? It's only pertaining to arrears, because rest of the things have been implemented pertaining to the arrears.
Telangana state
Not compliant, because in the amicus report it says virtually compliant.
How much have you paid?
They will not. None of the states are very smart. None of them will say how many judicial officers are there. They will say we have complied.
Once we
More
come
details
clear,
of
shall come clear on this. My filing everything follows.
I just for giving specific. May I just
State of West Bengal. There has been non-compliance by the state of West Bengal with the orders of this court. Full stop. The time has been 1 year's time is sought for effecting compliance, which is unreasonable. Full stop. We grant time for full compliance till 15 August 2024. We'll keep the matter for reporting compliance on 20 August, we'll keep the matter. We extend time for compliance until 20 August 2024. We'll stop. The proceeding shall be listed on 23 August 2024, on which date both the Chief Secretary and the Finance Secretary for the state of West Bengal shall remain present before this court with affidavits indicating compliance.
All states, just bring to your lordship's notice. All state government and union government with
2016, that was the 7th Pay Commission. We are on the threshold of the next Pay Commission, 2026, and yet our judicial officers after 8 years, 9 years haven't received it. It's not as if it's a separate case for judicial officers. Most of these recommendations are at par with state government and union officers.
We are constrained to pass the above order. We are usually circumspect in directing the personal presence of the officers of the state. Full stop. However, this is a situation where the officers, the bureaucracy has received the revision of their pay scales and other allowances with effect from 1 January 2016. Full stop. Judicial officers are yet to receive the revision, the revised pay scales and allowances. So the arrears which are due to them in terms of the SNJPC, so 8 years have elapsed. Full stop. Despite, as we have already noted, despite sufficient opportunities, there has been non-compliance. Full stop. It is in this backdrop that we have been compelled to pass the above order. So then,
instead of bureaucracy, your lordships may consider administrative officers in the executive.
Bureaucracy, administrative officers in the executive.
It's a better word. That's
better.
Manoj, just one thing. Manoj may not say that State of West Bengal has not complied. Manoj may kindly say partially complied, as the amicus has stated, because it seems that we have.
But you have not told us how much you have paid. You tell us how much you have paid. Then you would have reckoned.
I'll come back on this and just.
Anyway, you now you figured all right. Which is the next one now?
Just only one thing. If just in case we are not complying by 28th, then Manoj may require the presence.
No, now here they have to remain present with an affidavit of compliance. Otherwise, we'll send them marching from here. Yes.
Plus, Chhattisgarh also concern is the allowances, but if your lordship, the tax, God said there will be an
tax will pass a separate order.
Again, the same thing in Chhattisgarh also. They will say we are considering whether we should grant those allowances. I don't understand those GOs. With all due respect, after there is a Supreme Court judgment, the subject matter of all those GOs mentions the Supreme Court judgment of 4th January 24 and then says we will now consider whether we must grant those allowances.
Where is that in your note?
If your lordships kindly see page 10, Chhattisgarh Millards, your lordships will see committee is considering upon the mode of payment of concurrent charge allowance. State has issued geo dated so and so sanctioning increments on acquiring higher qualification, but no date has been mentioned. All that is clear in your lordship's judgment. There's no question of now saying that we will deviate from your lordship's judgment. And your lordship will see this.
State of Chhattisgarh, the geo issued by the state indicates that the committee is considering the mode of payment of the concurrent charges allowance, correct? The concurrent charges allowance. The state has issued a GO sanctioning the increments on acquiring higher education qualification, but no date has been mentioned for effecting compliance.
And out of 20, only 11 have been sanctioned.
And full stop. Out of 20 allowances, only 11 allowances have been sanctioned. Full stop. The state, the conduct of the state of Chhattisgarh is plainly unacceptable. Full stop. Despite 7 opportunities, 7 are there also, no?
Everywhere.
Despite 7 opportunities, the judgments of this court have not been complied with. We direct the personal presence of the Chief Secretary and the Finance Secretary of the state of Chhattisgarh before this court on 20 August 2024. 20 August bola tha na?
23rd minutes.
23 August 2024, together with affidavits of compliance, failing which the court would be constrained to take recourse to the exercise of its contempt jurisdiction. All right, that's Chhattisgarh. Then full compliance by the 23rd. Yes, and the Chief Secretary and Finance Secretary have to be personally present in this court on that day. Now we are not going to say that if you comply with, then you need not be present, because then they'll not comply with. Only if we now direct presence that they will comply with. We now know how to extract compliance with the order. Yes. We're not going to send them to jail if they comply, but they have to be present here and tell us that they have complied. Nothing doing now. Yes, which is the next?
Delhi, my lords, page 12, no allowances, no arrears of allowances have been paid.
Delhi?
No allowances, no arrears of allowances. Last two points.
The government of NCTD has not complied with the orders passed by this court. Full stop. No case for extension has been made out. Full stop. We therefore direct full compliance with the orders of this court by 14 August, by 20 August 2023. The Chief Secretary and the Finance Secretary of VNCTD shall remain personally present before this court on 23 August 2023, together with affidavits of compliance for the purpose of reporting compliance, failing which the court would be constrained to take recourse to the exercise of its contempt jurisdiction. Then,
Lords, Assam, no compliance. They have moved an IA for extension saying citing floods because there was no floods in the year of.
Filed an affidavit, Lordship. Lordship, we have issued the notification. So far as 14 heads are concerned, Lordship, we have issued the notification, the report, because it came later, Lordship. That was the only thing, Lordship. The time, Lordship, that is being taken, Lordship, is we are really, Lordship, now facing disaster.
The council appearing on behalf of the state of Assam states that a notification has now been issued for the payment of 14 allowances.
14 allowances in the time.
Full stop.
Not 7, Lordship, 6. Lordship said 7.
There has to be full compliance with the orders of this court. Full stop. This court is not inclined to grant any further extension of time or exemption to the state. Full stop. The Chief Secretary and the Finance Secretary of the state of Assam shall remain personally present before this court on 23. There should be, so ऊपर जो लिखा था ना 20th August and 23 August. Same order.
Lordship, our situation is a bit critical, Lordship. This because of disaster situation.
Yes, these are people who are working. These are people who are working in service.
Yes,
you have to pay them now and just give opportunities.
Lordship, may I just submit, Lordship? Lordship has given time to the other state till 15th of August.
20th August we have given you. We have given you time until 20th of August, paid by 20th of August, and asked the Chief Secretary and Finance Secretary to be in court on the 23rd of August to report that they have complied. Then you will we'll put an end to the matter.
That may be exempted, Lordship. We are in a genuine situation.
Then I don't know what will happen. Then there will be another application for the extension. Once we say this,
Lordship, we are in a equally a disaster situation. We are facing it, Lordship, in the state. Lordship, everyone is.
How much is the amount that you have to pay?
Lordship, I suppose it is more than 100 crores, Lordship. More than it will be for a state like Northeast, and we are facing floods, Lordship. It is the third round of floods. It is the third round of floods.
Ask the government of India to pay you. They'll pay you from some other head. Yes.
Lordship, Lordship, our case, Lordship, may kindly consider.
No state.
The other states will not come out with this situation, Lordship. Our situation is a bit critical, Lordship.
We'll not do anything like
Lordship,
that.
Consider it on the next day, Lordship. On 23rd.
Still to remain, we'll see if
Lordship, 23rd, if we don't show any progress, Lordship, kindly consider.
On the 23rd, if you are not able to pay, let the Chief Secretary and Finance Secretary come here and tell us why you can't pay. We'll consider your request. But they must remain present.
Lordship, that's what, Lordship, I was only requesting, Lordship. Kindly pass that order on 23rd, Lordship, which we don't do. Lordship, we are in a situation, Lordship. We are in a critical situation, Lordship.
Tell us from when did your
otherwise I would not have pressed it, Lordship.
Tell us from what date did you revise the pay scales of your administrative officers?
That we have complied, Lordship.
From which day?
So far as the administrative officers. So far as the SNJPC, Lordship, we have complied with everything, Lordship.
No.
That I can't offhand tell, Lordship, from which
when have they got We'll tell you. 1st of January 2016.
Lordship, we have complied with every direction of the SNJPC, Lordship. We have complied with everything.
The point. We'll pay the state civil service officers. Judicial officers are not our.
Lordship, I am not making a legal argument, Lordship. I am not making a legal. It's on a different criteria, Lordship. It's only on
who else, Mr. Parmeshwar?
So far as Guwahati High Court is concerned, my lord, Arunachal, Nagaland and Mizoram, my lords, notifications are there, but release of funds is, according to the last affidavits, not comes. So your lordships may direct the same direction so far as Arunachal, Nagaland and Mizoram.
The same direction shall apply to the states of Arunachal, Nagaland and Mizoram. Then,
for the state of Nagaland, all the information has been collated, is scrutinized, is just pending with the finance department, Your Lordship. There has been compliance. We've accepted all the allowances, Your Lordship. We kindly give us time And your lordship may not,
Until 20th of August.
insofar as the presence of the chief secretary in
We have to now, we have to secure presence.
because there has been substantial compliance, is just
Yes.
the dispersal of funds.
The compliant come here, come visit Delhi once, yes.
My lords, Gujarat, my lords, I am now told there is substantial compliance except TDS.
TDS, that will just pass an omnibus order.
Himachal Pradesh, my lords, the affidavit doesn't give us any information, fortunately. So far as
What is the position in Himachal?
even the
State of Himachal Pradesh में ऐसा लिखिए, the Chief Secretary and Finance Secretary of the State of Himachal Pradesh shall file a joint affidavit indicating compliance. Full stop. Since as of date, who's appearing for the State of Himachal Pradesh? Where is he? Who's appearing for the state of Himachal Pradesh? The Learned Counsel for the state of Himachal Pradesh is absent when the case was taken up. Is taken up. Full stop. The Chief Secretary and Finance Secretary of the state of Himachal Pradesh shall personally remain present. Will be same order, huh? Let them come here. Yes. Then
Jammu, Kashmir and Ladakh, my lords, no money payment.
Jammu and Kashmir and Ladakh, same order as
Complete non-compliance.
My lord, I appear for UT of Ladakh. May I assist your lords in case of the UT of Ladakh, my lord?
Yes.
My lord, in case of UT of Ladakh, all the funds are available with the two district judges, my lords, and the two district judges are the drawing and dispersing officers. The funds have been provided, my lords. The dispersal is with the learned district judges, my lords. My lords, may I have my compliance affidavit?
Regards the Union Territory of Ladakh, Mr. Piyush Beriwal, right?
Yes, my lords.
Learned Counsel states that the two district judges are drawing and disbursing officers, and the funds that we pay.
Yes, my lord. My lord, we have also filed this by an affidavit.
So Ladakh ke liye don't pass any order of presence.
Much obliged.
Jharkhand also same thing, my lords. No information on areas of allowances.
Jharkhand. Have payments been completed? Have you paid all the 20 allowances? Then same order for Jharkhand. Ask the Chief Secretary and Finance Secretary to remain present. Time until 20th. Yes. Then?
Karnataka is not a concern, my lords. Karnataka is not concerned. Kerala, my lords, not paid. They have moved an application for extension. They have not
Kerala, pay?
They have not.
That's all right. You ask the Chief Secretary and Finance Secretary to remain present. Kerala, the same order. Compliance by 20th, personal presence on the 23rd. 20th of August and personal presence on the 23rd. Yes.
As Madhya Pradesh also same thing, SOP has been made by the committee, your lordships constituted, but no disbursal.
Madhya Pradesh is the same. Madhya Pradesh, same order. Then?
Tamil Nadu, my lords, not a single paisa.
Tamil Nadu?
Grave defaulter.
Same order.
Manipur had a problem, my lords, they moved an IA over.
With respect to the pay and pension, everything has been paid. The allowances, they have been approved. The prospective payment of the allowances have started, and I have got a pay slip from the respective DDOs also. Because with respect to the areas of pay, that is the only problem that we have. Unless we were seeking a little bit of more time for extension.
How much do you have to pay?
This is about 24 crores. And the state is running into some deficit.
Yeah, pay it. Get it from the Union of India. Same order for Manipur.
Can it be a little...
20th August, now 20th August. It's uniform for everybody, yes.
Meghalaya also, my lords.
Meghalaya?
Same thing.
Same order, Meghalaya.
Lords, Orissa, my lords.
You're from Meghalaya?
I have instructions just now that the status was previous to end of financial year.
So 20th August. 20th August, ask the Chief Secretary.
My lords, I'll file an affidavit which has been.
If you have paid, if you have paid, mention the matter earlier and tell us we have paid, we will exempt your Chief Secretary. Otherwise, he has to be present here.
I'll mention the matter.
But so far as Odisha is concerned, my lord, 6 allowances they decided not to do.
Orissa,
and so far as the arrears is concerned, they themselves decided that they will pay it over 6 or 7 installments.
Same order.
Not as far as the
Take order, लिख लीजिए. 6 allowances have yet to be paid.
Lord, as far as State of Odisha is concerned, the resolution of the Finance Department has come in on the 16th of March 2024, and the Law and the Home Department have submitted the proposal in the ensuing session for release of the funds in the Odisha legislature. That's the instructions which I have.
Learned Counsel for the State of Orissa states that
the resolution of the Finance Department has been issued on 16/3/2024.
That the resolution of the Finance Department was issued on 16 March 24.
And the Law and Home Department has submitted the proposal for making the budget provision in the ensuing.
And the Law and Home Department have submitted proposals for ensuring payment.
The budget provision.
For making a budget provision in the ensuing budget session.
Ensuing Odisha legislature.
20th August, we are keeping compliant and ask the Chief Secretary and Finance Secretary to remain present.
Very well. Very great.
Yes.
And so far as Patna is concerned, I am now told, yesterday evening I received a note saying that they have started disbursal of all the allowances. But the last affidavit which was filed said that allowances have not been paid.
Now, it has been.
Punjab and Haryana High Court, again, the committee filed an affidavit.
Bihar, as Learned Counsel for the state of Bihar states that an amount of rupees 122 crores has been transferred to the Law and Judiciary Department, right? And and the payments are being made in full compliance with the order of this court. Good stuff. Then
Punjab and Haryana, my lords, allowances arrears have not been complied with, and allowances future payments are partial compliance. Your lordship, see the last 2 columns.
So same order for state of Punjab, ऐसा लिख लीजिए. Same order, we'll say full compliance we should.
There is an issue with respect to state of Punjab and Haryana. The matter is pending before the full bench of the High Court. Allowances, that's why they were not released. The state has complied with it. Your lordship may see the note as well. There's an SLP pending before this court, pursuant to which the High Court has held its hand and not released and not granted this approval.
Which allowance? Which allowance?
What times? So except for super time,
that we have been done, your lordship, for the state of Punjab. For the state of Punjab, we have done, your lordship. Only that matter remains pending before the High Court. Page 116.
All right. State of Punjab के लिए ऐसा लिख लिया. Which where is page Punjab is
page 1168, your lordship.
That's in respect of, that's not allowances. That's only selecting time and superscale. That's litigated between the judicial officers. Therefore, that full bench I've examined.
What about the allowances? Have you paid the allowances?
Your lordship, we'll place that on record, your lordship.
Sorry?
We have released the allowances 11th April 23, your lordship.
We pass the same order. If you have, come back to us, file an IA before the next date of listing. We will and give it to Mr. Parmeshwar. We'll verify it. We'll delete the requirement of the presence of your chief secretary.
But to that effect, your lordship.
So you first ensure that the full payment is made. File an affidavit. Give it to Mr. Parmeshwar. Come here and mention it. We will exempt appearance.
Rajasthan, same order as the others. No information has been provided to this court in the complex.
Rajasthan. All right. Anybody else?
But I'm sorry, my lord. I was just trying to say something, but I was not unmuted, my lord. For Delhi, my lord.
Yes, for Delhi.
Problem for Delhi. Yes, my lord. We are waiting for the approval of the central government because we can make payment only once the central government approves.
We are not concerned with that. You sort it out with the central government. We want payment to be made. Yes.
Let's in that Punjab and Haryana, the other order continues.
Central government has permission. This.
Haryana. High courts because the Haryana, the other orders continue because they have not paid up the allowances.
Haryana same order will continue.
And Punjab is order.
Punjab का हमने एक order pass किया था.
Telangana state में Rajasthan, considering this that the central government has filed review petition
Punjab and Haryana, we have passed the same order. Punjab, Haryana, the same order of personal presence.
Right.
Provided if they come back here and file an IA saying that we have paid, then you can tell us. We will. You can mention, Parmeshwar, that these states have been. You can come and mention so that.
So that's so far as Rajasthan, Sikkim, Tripura, and Uttarakhand are concerned, my lords. Rajasthan, Sikkim, and Tripura the same order. Allowances have not been paid.
Rajasthan, Sikkim, and Tripura same order. And
Telangana has complied. Uttarakhand, the only issue is TDS.
All right.
Because on TDS, I just one suggestion.
As for Sikkim, may I make one submission, my lord? May I request for a similar indulgence as the previous council? Once I file the updated status of allowances, may I make a request for exemption for appearance, as my lords have permitted the previous councils for other states? Because I'll get the updated status and ensure that the allowances are paid.
Let them be, let them
Similar
let them appear, yes. Sorry.
As far as TDS is concerned, would you want to pass an omnibus order saying wherever the exemptions are offered under the 1936 Act, so far as allowances are concerned, no TDS should be cut, because there's no point in going allowances one by one.
Wherever exemptions are wherever exemptions are available under the provisions of the Income Tax Act 1961, from the deduction of TDS on allowances, the state government shall ensure that no deduction of TDS is made.
And wherever deducted, my lords will give them time till September to return that, because then this is complete deductions. It'll have to go back, because this is 1 minute. The state government is deducted so that
wherever the state governments have wrongly deducted the TDS, they shall refund the amount to the judicial officers on or before 15 September 2024, with liberty reserved to them to pursue their claim before the department.
Hello, I have with my note which I have circulated, I have put an appendix A where I have encapsulated under the Income Tax Act which all allowances that are part of the SNJP are exempted under the Income Tax Act. So my lords, if something like that can happen, and I've also annexed along with my note the payment slips of the judicial.
All right, what we'll do is that we'll take up, we have covered the states, right? On the issue of TDS ka baad mein dekhte hain. We'll keep it on Monday. Just look at what she has said, the allowance, examine.
My only fear was that.
Can you serve the Central Government Council so that we can then deal with TDS on that? Just ask Mr. Venkatraman to remain present here on Monday. You can tell him what the issue is so that then we can clarify it.
Just housekeeping, sorry for that.
Yeah.
So that all those contents in the IS can be disposed of unnecessarily.
For Telangana state, my lord, no complaints. For Telangana state.
Where are they?
Page 26 of my.
Yes, there are eight contempt petitions. Yes. Page 26 ko serial numbers 1 to 6 IS stand disposed of.
Similarly, those 8 orders dated 22 of them merge in those contempt petitions.
Telangana state, my lord. Telangana state.
27, there are a number of IAS and petitions for intervention prior to your lordship. Those also can. Every time.
All serial number 1 to 17? Serial number 1 to 17 का जो पेज 27 और 28 को है वो भी डिस्क्लोज
Your lordships may mention on IA.
So what we'll do is
your lordship on IA. Lordship. With your lordship's permission, Millers, may I?
Well, in the afternoon today, the NEET.
I'll just log in.
The matters on Monday, including NEET, also we'll take up on Monday.
May I have your lordship's time for just half a minute? Can I have the attention of the court for just half a minute?
So we'll take up NEET tomorrow first on board, and then we'll proceed. Mr.
May I have your lordship's attention for a minute?
That's serial number. 38, my lord. 38, kal rakh do. 38.
Very obliged.
Lordship,
Maharaj, if 38 can be on Monday, my lords, we need take instruction and we'll place something on record also, my lords.
Mr. Ranjit Kumar, yesterday the solicitor was also saying that he will require a little time.
Again, today has been passed.
Place that on record, my lords. Nothing worse has been passed, my lords.
What is being happening is, Virat, as I mentioned yesterday, not about curiosity, what happened. 9th July, they say, no, that order is no. They're not 10th again, because
Can we take it up on Monday?
July, they say, no, that order is no. They're not 10th again, because
Can we take it up on Monday?
I have put an appendix A where I have encapsulated under the Income Tax Act, which all allowances that are part of the SNJP are exempted under the Income Tax Act. So, my lords, if something like that can happen, and I've also annexed, along with my note, the payment slips of the judicial.
All right, what we'll do is that we'll take up, we have covered the states, right? On the issue of TDS ka baad mein dekhte hain. We'll keep it on Monday. Just look at what she has said, the allowance to examine.
My only fear was that.
Can you serve the central government council so that we can then deal with TDS on that? Just ask Mr. Venkatraman to remain present here on Monday. You can tell him what the issue is so that then we can clarify it.
Just housekeeping, sorry for that.
Yeah.
So that all those contents in the IS can be disposed of unnecessarily.
For Telangana state, my lord, no complaints. For Telangana state.
Where are they?
Page 26 of my.
Yes, there are eight contents.
Personally not available. Can it be Wednesday?
Wednesday, fine. Yes,
Correct.
Wednesday, fine. Wednesday, fine. We also have to go through it.
Other matter on Friday.
Wednesday is fine.
My lord, Monday and Tuesday, my lord, me and Learned AG both are out of Delhi, my lord.
Keep NEET on Wednesday because
Wednesday, my lord, I'm grateful.
Others on Friday. Others on Friday.
Thursday.
They joined. 1 second, just say this.
Thursday, my lord. Wednesday is a holiday.
In compliance with the order, the previous order passed by this court, affidavits have been filed by the NTA and the Union of India.
They are not served.
Mr. Nedumbaran, you are not the judge. Fortunately, I am the judge. Please quiet.
I'm here to develop.
The NTA and the Union of India have filed their responses. Stop. In order to, some of the learned counsel have not been able to receive electronic copies of the responses. In order to enable parties to apply their to consider the responses which have been filed, the further hearing shall be listed on Wednesday.
Wednesday is a holiday.
No, Thursday. No, Wednesday is a holiday.
common rejoinder could be filed, rejoinder.
CBI has not filed this status.
CBI has already circulated the status report to the court. We'll see on insofar as.
Yes, my lord, we'll go according to your lordship's direction, my lord.
My lord, one of the cases.
Thursday.
It's item 40.
Sorry. What should be published? That suggestion was made last time. We said we'll consider it when we take it up. We'll consider that request on.
Item 42 is a transfer petition. Lordship issue notice on that. NEET matters.
That's the transfer petition and the NEET matters. 42 years. That's 42 we have to issue notice.
My lord, in All India Judges Matter, my lord, I'm sorry. When the case was called, I was just trying to rush in. My lord, I am for the state of Himachal Pradesh. My lord has marked my absence.
Ask your Chief Secretary and Finance Secretary to remain present on the 23rd of August. By 20th August to comply. But they have to be present in court to indicate that they have complied.
My lord, my presence.
All right, in card. Very much.
These are very rare standing orders, your lordships. God, why are they keeping?
difficulties, the topic that doesn't open, my lords.
No, I didn't.
Against
These matters may be kept on my.
matter will against.
My lord,
Just do this.